Hello and welcome to NewsClick. Today we have with us Dinesh Abrol from the National Working Group on Patents. We have now the national IPR policy, the intellectual property rights policy. It seems to be geared exclusively on the basis of knowledge being privatized as the only road to innovation.
If you look at the policy as it has 7 objectives, and in the 7 objectives, you can also see references to open source and FOSS and free and open source software, drug discovery. But actually a lip service only has been paid to those paths or those routes to development of innovation. Essentially, the focus and the thrust of the policy is on exactly what you were saying, that IP is considered as private right. It's considered a basis for all innovation, and they want to maximize the incentive to the IP owners, intellectual property owners, be it any form of IP, because this is India's first of its kind policy which covers all the forms of IP together using one set of principles, and the principles are clearly tilted in favor of IP owners, intellectual property owners.
It also talks about how the government or public institutions, universities and so on, government research institutions must also incentivize IP and intellectual property. That means all publicly funded research output should also be privatized. That seems to be, again, the other part of what this policy is saying. And the various places it refers to the need to create intellectual property from the universities and public funds which have been given to them, to the research institutions which public funds have been again given. And it doesn't seem to believe that if it is publicly funded, then the result should really benefit also the public.
You and me were both involved in stalling the Bayh-Dole version of the Indian version of Bayh-Dole Act, because we believed in India not going for intellectual property route of the kind which the Bayh-Dole version suggested in the case of public sector research.
The Bayh-Dole Act being the US attempt to really privatize public funded research. That was the first of its kind in that sense, as a model which was used.
Though we could stall it, but I think whether it will come back or not is anybody's guess. But what appears is the kind of emphasis that you yourself have just now suggested that it is taking in respect of public sector research institutions, whether universities or other. They really want to go in the direction of actually these institutions being encouraged to file more patents, license them in a non-exclusive way, exclusive way rather than non-exclusive way. And if you look at the experience of the CSIR, because the Council of Scientific Industrial Research was one of the first few research councils in India under Mashelkar's leadership, to actually say that move away from publishing and move to patents as a form, and also wanted to move into exclusive licensing of intellectual property, and that's what has been practiced. But if you look at the results, the outcome of that particular policy, it has costed the exchequer, the treasury, quite a lot, and we have not been able to use very many patents. And in only 4% of the cost have been possibly, finally realized in the form of revenue. But more importantly, if you look at, the failures or the sources of these failures are because there is no planning of actually R&D for technology development to the extent that when you are wanting to insert yourself into the overall intellectual property system, that's why it's not, the attempt even was very, very weak with regard to this done. And I don't see, even if somebody suggests that, okay, fine, public sector research institutions can use patenting. They used actually at one time, but they used it in very differently, like process patents used to be filed in the case of CSIR. But Indian pharmaceutical industry grew without actually technology being licensed to them. It was shared through actually transfer of personnel.
But coming back to the other issue, see, when you look at countries which have developed late developers, which is what we are at the moment, late developers have always been much more open and not taking the patent route. It's the incumbents, the monopolies, the older countries who hold the bulk of the patents. England at one point of time, the US at that point of time used to really do what now would be called pirating, which they call pirating now. So this whole issue does mean that if we're a strong, developed country with lots of monopoly rights on technology, and what a new developing country does, are quite different.
No, you are very right. In fact, a strong IP is a barrier to collaboration between science and industry. In fact, that's what the experience of both seed industry in India as well as the pharmaceutical industry indicates very clearly. The collaboration between 18 laboratories of the CSIR and the Indian pharmaceutical industry occurred in absence of product patent or a patent system which actually provided for license of rights, automatic license of rights as well. So, in fact, in very few cases when, as I said that earlier to you, that licensing route was used, but even when it was used, it didn't mean much cost. So, there was openness as far as concerned. Same is the case with the seed industry as far as concerned.
And also with the software industry, which has really grown initially, including Microsoft and Google, which are supposed to be the big ones, have grown under really no patents for software.
No, if you look at microprocessor, integrated circuits, Semiconductor Chip Design Act wasn't there. It came much later when these technologies were evolving, which are foundational elements for today the ICT, the information communication technology. Software grew under copyright to some extent, initially. There was no patents at that time as far as concerned. And the copyright is, is a very different, let's say, system compared to patent. The stronger IP was not the basis for development of any of the new generic technologies.
So the whole argument of this policy document that IP fosters innovation is in principle wrong, and that's the historical experience that we all have. So it seems to have been more done to help what the US trade representative wanted, that India should have a quote-unquote strong IP regime. And that's what they've been pressing for, including changes in laws. And this document also talks about possible changes in domestic laws. That's a very significant danger signal to the pharmaceutical industry and the famous 3D clause of the Patents Act.
Now, before I come to the issue of how it is a gift to the US administration because Modi is visiting the US on 7 June 8, we'll come to this issue. I want to mention, if you look at the experience of the Indian pharmaceutical industry post 1995, I just now analyzed 262 drugs which have been introduced since 1995. It is really the delayed product patent which has saved us. Because we implemented product patent with the help of the left support. UPA 1 was supported from outside the 2005. In 2000 also, 1996.
Left's pressure to change the patent amendment which came in 2005.
Now, if in fact foreign firms have the market power has risen over the period as far as concerned, but the results could have been worse if you compare them with the Latin American experiences, because they did early implementation of TRIPS. They did it actually from 1995 onwards. All the Andes and all the Latin American countries, their industry did not actually take the benefit. As a result of the Hatch-Waxman Act, could not really build a generic industry. India could build a generic industry precisely because we had that space, and that space was created precisely by a more balanced IP system which we through struggle created in India. So, if you go by that experience of the post 1995 period, the innovation or the capability development has not occurred on account of strong IP. So even the recent experience, forget about international experience of early other technologies which we were talking of, or now of course you were bringing in 3D printing, the Indian own experience very, very clear as far as the pharmaceutical industry is concerned, that the strong IP is not in the interest of, and areas where product patent which are hence patentable from post 2005 period onward, that is many areas we see now in very many therapeutic groups the rise of the market power of the foreign firms.
Particularly for new drugs, which are
There's
post
the case of
2005.
whether it is the
Cancer
anti-cancer,
drugs.
cardiovascular, urology, the CNS systems. In many of these areas, this is what is happening.
Coming back, you were saying about the gift to the United States, that this opening or presenting this IPR policy at this particular point of time is really to make grounds for quote unquote a triumphal visit by Mr. Modi to the United States, a gift to the United States. How do you look at that?
See, let's read it in the context of two developments which have occurred. That is, one is the mega regional. Nairobi has failed. India did not play its due role as far as concerned. And we had earlier here discussion.
There's a WTO
Discussion. And the US could push the case for say new issues and 21st century issues. But outside, as you know, the WTO, they have been pursuing mega regional like TPP, the Trans-Pacific Partnership,
TPIP.
the TTIP, and now other also together. RCEP is being regional cooperation, economic partnership is being also pursued. Now, if you talk to the ministry officials, and several seminars and conferences on trade and investment, one has interacted with them, saying India cannot remain outside the mega regional. It cannot be out of them. So, like the TINA syndrome, that there is no alternative as far as is concerned. So, we are willing to go into mega regional. But mega regional represent TRIPS plus provisions. They allow patents for new uses of drugs, for example. Which we rejected in the Indian Patent Act.
Which means the Patents Act will have to be then revised. That's the implication of, and that also the policy document says clearly.
Precisely. And they say that we are willing to engage with the multilateral treaties because they are in India's interest, if, of course, they put it that way. And they also are saying that if laws need to be changed, they can be changed.
And they would all change the Indian Act.
And they would change the Indian Act.
So we seem to have given some assurances of future change of acts, which is what is contained in this document. And that's a prelude, you think, to Mr. Modi's visit to the United States?
See, immediately you may not see the change in the law, as far as I understand. But see, if you look at the quality of the patents, which should have been actually targeted. Section 3D, in fact, there is a study which is already available, has not been implemented by the examiners properly, because examiners themselves are not very well trained. And also, of course, the other point which continuously gets made is that there is not enough examiners and they are going to raise the examiner. But I think the issue is not just more examiners. The question is also the quality of the patents needs to be checked consciously. But if the policy gives a signal that, more patents, more innovation, then you won't be able to focus on quality of the patents.
The last point is that this government seems to be moving in the direction, and Mr. Jaitley's statement while releasing the policy, is that we need to help big capital in India, and that's why the IPR policy has to change to take care of that. So this is a conscious effort to move this whole patent regimes to help big capital. And that would also be the increase in drug prices, the increase in other prices to the consumers. So it's really moving against the consumers, against the poor, to help the big business. Would that be the way you would read this?
See, of course, if you heard Jaitley when he released this particular thing, he paid lip service to the fact that drug prices should be controlled and so on, etc. India needs cheaper drugs and so on, etc. But if you look at the other statement which he made in that particular press conference, that is that trademark registration would be now accelerated. It would be very easy, like the ease of business, ease of trademark registration. He emphasized that that's one of the benefits that you are going to derive out of this. And if you look at even the last, we haven't filed too many patents as far as Indian creativity and innovation, which is actually being, thought of should need to be protected. There isn't at that moment much of that activity which can be even protected. What we have seen is the rise of trademark applications. And the trademark applications are maximum in the area of medicinal areas. So it's through the brand name that the monopoly is built, and it is through the trademark that you see on the top of the patent that also the more profits are obtained and the prices are raised and so on.
This is all the time we have today. Keep watching NewsClick for further developments.